rise if able. Appeal in the matter of Siddique, Appellant, and HDI Global Specialty SE.
Good morning, my lords, my lady. There is nothing as strange as litigation, and certainly taken an unexpected turn because there are discussions going on. Obviously, I can't say what they are, but there are discussions going on between my instructing solicitors and Mr. Bailey's, and I'm told they're on the verge of an agreement and expect to reach that agreement within an hour. If that is the case, then plainly it would be prejudiced by any decision being made or argument being concluded. I've spoken to my learned friend about this. If the court were minded to give us an hour, I'm satisfied we still finish today. But I'm in the court's hands as to what we do.
I think we go on, really, Mr. Halfon. I mean, you know, the parties have had a long time to try and settle this case. The other one settled whenever it was last week.
Yes.
If it was going to this was going to settle, it should have settled before we began the appeal, frankly, because I doubt very much whether, no disrespect to you, but I mean, we've seen everything in writing. Really, both of you have been, or all of you have been developing points in writing, but I don't think we've been sprung with any new point that we didn't spot coming. So speaking for myself, I can't see anything you say in the next hour is going to make any earthly difference to whether the case settles or not.
So be it. Well, I will continue. There were 3 pieces of unfinished business from yesterday arising out of questions asked by my Lord Justice Lewison. The first one was a question about the judgment in Matadine, which is at page 346 in tab 33.
This is the Privy Council case.
Privy Council case, yes. And it was paragraph 38 on page 346. And my Lord asked a question as to what was underlying this reasoning. I'm not sure if I fully understood the question, but the way I understand the position is as follows. The insured had car insurance which covered both third-party liabilities and damage to his own vehicle.
Yes.
And what Lord Brandon was saying was that what was transferred, the rights against the insurer which were transferred were limited to the rights for third-party indemnity and did not, for obvious reasons, include the right to have the vehicle repaired. And that, in my submission, is consistent with the 1930s.
Well, what I was puzzling over was how you get to the position where part of the rights under the policy get transferred to the third party and other parts of the rights do not.
I see. And I'm sorry.
As I had thought,
yes,
the 1930 Act transferred everything to the third party.
No. If we...
I don't think it does.
No, it doesn't. If we go back to the 1930 Act, which is at tab...
Well, I think it's
tab 11.
Trinidadian
It's a Trinidadian equivalent. Yes, perhaps we should look at that.
Paragraph 20.
Yes. So where under any contract of insurance a person is insured against liability to third parties. So that's the context.
The point is this is liability insurance. So if you have an policy of insurance which has 2 sections, one covers in this example the damage to the vehicle itself.
Yes.
The other covers liability to a third party.
Yes.
Then it's only the liability section that is the subject of the 1930 Act.
Yes.
Or its equivalent. That's the point.
Yeah. But in fact, it's even more limited than that because it's only the shows in action, which is the right to be indemnified against that particular claim, which is assigned, because that's clear from Cox and Bankside, where there were lots of claims, and there's a different assignment to each insured.
Yes, all right. Thank
Sorry,
you very
to
much.
each victim.
That clears it up, thank you.
Yes. So that was that issue. The next issue was a rather difficult question. That was put to me about guarantees.
Sureties.
Sureties, yes.
And the answer isn't in chapter 7, I'm so sorry.
It isn't. But
Maybe in the next edition.
we've handed up, I'm afraid, yet more paper with authority
So
on
you've
this.
got Vosloo.
Oh, right. Oh, gosh.
And we've handed
That
up
was
Oslo, which my lady will well remember as a
Pretty
case
tried stuff, yes.
that she was in front of Mr. Justice Blackburn. So Oslo is at page 1592. It doesn't actually deal with the limitation point, but it contains some general observations about how suretyship works. 21, 23.
What do you want us to do with these?
24 and 25. In short, our submission is that there are two separate contracts and they each have their own limitation period, and it's very often the case that there has to be liability of the principal before there could be liability of the surety, but it all depends on how the thing is worded. And there are some cases where, for example, one contract may be in writing and another may be under seal, and so you may get variant limitation periods. So it all depends on the particular contract.
I think the answer, Mr. Halpern, is actually that the surety is never going to take advantage of a limitation period that is in the contract belonging to the principal, because it's all procedural, unless it's a substantive, unless it's a foreign contract with a substantive limitation period in it. And the classic example of where it wouldn't happen is where the guarantee is a guarantee payable on demand, not a demand guarantee, but payable on demand. So the time for limitation purposes against the surety kicks off when the demand is made and not when the underlying default takes place. So you've got a disjunct between the two, and in that situation, the surety will have their own limitation defence 6 years after the demand, but that may take place more than 6 years after the principal. And so there's a complete disjunct between them, and the surety would not be able to say in that scenario, but the claim against the principal is time barred.
This is Reed Brown, I think. Is that right?
Well, Reed Brown, that line of authority,
yes. I'm grateful. So it probably turns out to be a rabbit hole.
Yes.
I think it sounds like a rabbit hole, Mr.
Very interesting rabbit hole.
Interesting. Now, my learned friend has asked that another authority be added to the bundle, John Doyle and Erith. And all I'm going to say about that is that there's an observation of my Lord Justice Lewison in that first of General Rolling Stock.
This is an observation about general rolling stock.
It is. I'm not sure what my learned friend makes of it, so what I'm going to propose, if this is convenient, is that I'll deal with it in response to him when I've heard what he has to say about it.
Well, if it helps, my lord, just to save time, it's one paragraph. We can briefly look at it. It's at page 1647.
Sorry, 1547.
1647.
1647, yes.
Yeah, paragraph 149.
And it's paragraph 149 in the judgment of my Lord Justice Lewison. And it's really the second sentence of that paragraph where we would say, my Lord Justice Lewison accurately and correctly encapsulates precisely the rolling stock principle, namely that once a company goes into liquidation, time ceases to run under the Limitation Act 1980.
Yeah, let me respond to that very briefly. paragraph 111 of the judgment, the start of Lord Justice Lewison's judgment at page 1639. Oh, sorry, I should say, going up to the previous paragraph, Lord Justice Edis agrees for the reasons given by Lord Justice Coulson that the appeal should be dismissed, and Lord Justice Lewison at 111 agrees with Lord Justice Coulson, but then he says the appeal raises a wider point, and he then deals with his own, with the wider point which the other two don't deal with. And that's the actual issue in the case is about adjudications and is, I think, not relevant to this appeal. So what we would say with respect is that Lord Justice Lewison is using the shorthand terminology that was found in Larnell, but that doesn't really change anything in relation to the submissions that I've made. My Lord's final point was about administrations, and if I may, I'll deal with that under Section 6 of the 2010 Act. May I just, before I move on to the Act, make one final observation about the 1930 Act, and that is in relation to Cox and Bankside. My learned friend, Mr. Lynch, says that what I said about Cox and Bankside was a red herring, and I've reflected on what he said, and to some extent he's right, but I think there is still a relevant point that I can make briefly, and that is that general rolling stock is made up of two elements. There's the element of fixing a date, and there's the element of pari passu distribution, and the two of them go together, and there's no sense in fixing a date unless it's for the purpose of pari passu distribution. So perhaps that's another way of saying it reinforces the question of whether one is looking inside the liquidation, inside the collective enforcement procedure, or outside it.
Yeah.
That's the point. Let me turn then to the 2010 Act.
Yeah. We've got that in, have we in two places or?
Yes, it's I'm afraid at the back of the bundle. It wasn't in the bundle at all. When we noticed that, we asked that it be added. So it
Got something else. We got it in a different location as well, haven't we?
You have it in another location,
Right
but
at the back of authorities 4.
Yeah.
yes,
That's
It's now outside it.
yes, that's probably where it ought to be.
My Lord, just so there's no confusion, at the beginning of the bundle is the Act as it was enacted. At the end of the
Yeah, I
bundle is
remember
the
you
Act
saying yes.
as it is today.
So, Section 1, subsection 1A and 1B sets out the situations in which the section applies, and subsection 2 provides for the transfer of the rights of the insured against the insurer, and we accept, and I think it's common ground, that in that sense the Act is the same as the old Act. No new rights are created. It's a transfer of the existing rights, and the right being the right to be indemnified in respect of this particular matter. Section 1, subsection 3 allows the third party to sue direct for a declaration, but he can't enforce it. He can't enforce those rights by getting any money without having established the liability of the insured, and that is new, but is purely procedural, and we say that is the reason why Section 8 of the Limitation Act has nothing to do with this, because no substantive right has been created. And we accept that that's clear from cases like Woodison, and also clear from cases like Eurocruit in a different context. My learned friend, Mr. Bailey, had an argument, if I may say so with respect, a somewhat half-hearted argument, that there might be a new limitation period because there was an extra ingredient involved, namely the need for the insured to become a relevant person. But one could say the same in Eurocruit about the need for a liquidator to be appointed, but that doesn't turn a misfeasance claim into something which has its own limitation period. So we say it's all procedural, and the underlying limitation period is the relevant one, and that is to say the limitation period for the claim by the by the victim against the insured is relevant to whether the insurance will pay up, and the limitation period of the claim for the insured against the insurer is relevant as to whether there is a claim on the policy. So there may be a claim on the policy, but it might not pay out because the original claim is statute barred. The claim of the victim is statute barred. So that we say is the correct analysis. Moving on to section 2 of the Act. I just note in passing that section 2.1 refers to a person who claims to have rights. That person is plainly the same person as the relevant person, but he hasn't yet become the relevant person because he isn't yet insolvent. So I think that's why there's a difference in terminology.
No, P is the third party.
I'm sorry, I've got that the wrong way around. I'm so sorry.
Unbelievably badly drafted, frankly.
It
He
is.
certainly knew how to draft things in 1930, even if he didn't get the law entirely correct.
Yes.
But this is just unbelievable. P is the third party.
Sorry, it's absolutely right. I meant to.
It's just, every time I read it, rather like you just did, I become confused.
Yeah, well, I substituted X, Y, and Z, and I hope that might make it a bit easier. But what I should have said is when it refers at 2.2a to declarations to the insured's liability, it's the insured who is the person that will become the relevant
The insured
person,
is the relevant person,
as and when they become.
as and when there's a liquidation or whatever.
Yeah, precisely. That's what I should have said. Yeah.
Wait a minute, they already are the
They
relevant
already
person.
are because
They are, yeah.
Because P is claiming to have rights by virtue of the transfer.
That's true. So
Section
in
one,
that
it has
case,
to be relevant.
it's hard to
already
see why it
happened.
doesn't say
That's
relevant.
why under
person.
1.1, it's under 1,
Yes.
it's already happened.
Yes.
The insolvency has already started.
Must have done.
Yes, it's I'm afraid not a.
None of this kicks in until there is an
That's right.
insolvency or.
I don't think it was. I don't think it was one of the law commission's better efforts in this respect. So 2.2a and b allow X to seek the declaration as soon as the victim to seek the declaration as soon as the insured becomes a relevant person. 2 subsection 6 allows says that the court may give the appropriate judgment against the insurer. So what that's contemplating is that you can bypass the insured, establish the insured's liability against the insurer, and then enforce against the insurer. But for obvious reasons, if there's any reason why you want to enforce against the insured, then clearly you have to join them in as well, and that's basic fairness. And the reasons you might want to join them in are because of a cap or a deductible or a reason why the insurer is able to avoid liability under the policy, or there may be other reasons. Then 2 subsection 4 says that the insurer may rely on any defence on which the insured could rely if there were proceedings brought against the insured, and that is plainly intended to include any limitation defence that is available to the insured against the victim. Leonard Friend says that the insurer can be in no better position, but equally he can be in no worse position so far as being able to rely on the insured's defences. He may have his own separate defences, but he can rely on any defence available to the
Now,
insured.
just pausing there,
Yes,
the insured could rely.
yes,
Given that we are in a situation where, as my lord has said, it is already postulated in subsection 1
yes,
that the insured in question is a relevant person, because
Yes.
otherwise there wouldn't be a transfer.
yes,
We are dealing with an insured who is in liquidation or in one of the other
Yes.
states that amounts to a relevant person.
yes.
So would you accept a defence on which the insured could rely must include a defence on which their representative, say a liquidator, could rely.
My lady, that gets more difficult because, of course, the general rolling stock.
Right, that's why I asked you the question.
Indeed.
But they can only rely if the proceedings were brought against them, for example,
Yes.
in this scenario. They can only defend those proceedings by their representative, couldn't they?
That's certainly right. But supposing the proceedings were brought, well, first of all, the proceedings may not be a liquidation. It might be one of the other methods.
Let's just assuming
it is a liquidation. It might be a creditor's voluntary liquidation. It might be a creditor's voluntary.
It might be, but let's just assume it's a liquidation.
Yes.
What's the answer to the question?
So the answer, if it's in creditor's voluntary and proceedings are brought by ordinary action and are not stopped, then the liquidator is entitled to plead a limitation defence.
Well, if we are in general rolling stock territory,
Yes.
then there wouldn't be a limitation defence after the winding up order was made.
I agree that if we're in general rolling stock territory, meaning that a claim is made to prove in the liquidation, then the liquidator would not be allowed to rely on a limitation defence. But that's for a reason that we say is because of the trust or statutory duty imposed on the
The difficulty
liquidator.
with that argument, frankly, is
Yes.
it's flatly contrary to Larnell, isn't it?
Yeah.
I mean, you know this. You spent quite a
Yes.
bit of time yesterday afternoon making submissions about Larnell.
Yes.
Which, and I think I said to you at the time that they seem to be predicated upon the assumption that Larnell was wrongly decided,
Yes.
which
Yes.
is not for this court to say. So far as the old route is concerned,
Yes.
Larnell is authority for the proposition that the Limitation Act doesn't run once the winding up order is made. What the as it were intellectual rationale for that
Yes.
is, we could debate no doubt
Yes.
for hours, but that is the law, and the real issue you've got to grapple with is why should it be any different in relation to the new route, the declaration route, which section 1 subsection 4A brings into effect.
My Lord,
in
I
relation to the other ones.
rely on Mortgage Debenture and Chapman, Lord Justice David Richards, in which he says that the reason why you that if proceedings are brought in a outside the mechanism of collective enforcement procedure by ordinary action against a company in liquidation and are not stopped, then that would result in the creditor jumping the queue, and that must be because that must be because the creditor would be able to enforce outside the collective enforcement mechanism, and if he's doing that, then Larnell has no application.
I don't begin to follow how that, with respect, Mr. Halpern, has
Yes.
anything to do with what the meaning of this statute is. Unless you're submitting that proceedings in subsection 4
Yes.
means proceedings in court or in arbitration, then you fall
Well,
right slap up against Larnell.
the section doesn't say what kind of proceedings are contemplated.
That's the problem.
Doesn't it? Where proceedings are brought under subsection 2A, so that's an
Yes.
action.
Yes.
The insurer may rely on any defence on which the insured could rely if those proceedings,
Yes.
that is, the proceedings which the third party has started,
Yes.
were proceedings brought against the
Well,
insured.
those proceedings would not be a proof of the liquidation. They would be separate proceedings. And so I make that submission. And I rely on what Lord Justice David Richards said. Yeah. The subsection 2.4 is subject to subsection 2.5, which in turn brings in section 12.
Yeah.
And I'll come to that in due course. But it should be noted that that is the only carve-out in respect of limitation. there is also the point that even if a judgment is obtained against an insured, that's not necessarily binding on an insurer if there are grounds on which the insurer could have challenged that judgment. I'm thinking here of the AstraZeneca case, which my Lord Justice Flo will be particularly familiar with because it was upheld at first instance on that decision. It's in tab.
Well, to say that I remember it would be an overstatement, really. It's a little while ago.
It's tab 43. I'm afraid I only, like Mr. Lynch, I have mine in 2 volumes rather than 4, so I'm not sure where the division is, but it's tab 43.
It's the tab.
And it's
Volume 2, I think.
Thank you. It starts at 563, and the relevant passage in the judgment of Lord Justice Clarke, Christopher Clarke, is at page 568, and it's paragraph 16 and 17. So, under English law, liability policy, generally speaking, and in the absence of wording to the contrary, policy which indemnifies the insured in respect of actual liability. This means in order to recover from his insurer, the insured must show he was liable to the person who claimed against him. Liability can't be determined in a legal vacuum, hence the need to assume a correct application of the law governing the claim in question to the facts properly found. In the event of dispute, the existence of liability has to be established to the satisfaction of the insurer or failing that judge or arbitrator. It's not therefore necessarily sufficient for the insured to show he's been held liable to a claimant by some court or tribunal or has agreed to settle with him. In practice, the fact that this has occurred may cause or persuade the insurer to pay, but if it doesn't, the insured must prove that he was actually liable. Under English law, the ultimate arbiter of whether someone is liable, if insured insurer can't agree, is the tribunal which has to resolve their dispute or any relevant appeal body. It may hold there was in fact no actual liability, and insured who thought, or another tribunal decide that there was liability was in error either on the facts or the law or both. Which is good information.
Well, that passage is dealing with substantive liability, isn't it?
Yes.
Yeah.
It's not really anything to do with whether they've got a procedural defence such as limitation. I don't read that passage as saying that the insurer can turn around and say, oh, well, the insured in defending an earlier action against him should have taken the time mark point. They decide that they don't. I mean, 9 times out of 10, there might be something in the contract of insurance that says that you can't settle or agree to an extension of time without the consent of the insurer, so it's probably an academic point.
The
case was concerned with a different issue.
Yeah.
I'm just reminding myself, I mean, there was no limitation issue.
No, I'm not citing it for any limitation point, but simply the fact that there is a judgment isn't necessarily conclusive. A judgment against the insured isn't necessarily conclusive.
Well, I think with respect, Mr. Halpin, it's the other way round. What it's saying is that you don't necessarily have to have a judgment against the insurer,
Yes.
against the insured, because you can prove liability by some other means. I think it's saying precisely the opposite.
Exactly. Certainly, you can prove liability by other means.
I
But
don't read this passage as saying, well, you can ignore what the judgment says.
not that one can ignore it, but that it's not necessarily conclusive. I think that's as far as I would.
I have real difficulty with that because, all right, the insurer might not be party to the underlying action and there might not be an estoppel
Yes.
in technical terms, but then the insurer is actually liable to indemnify, and the judgment would provide the basis of the indemnification liability.
Under the Third Party Rights Against Insurer Act,
Yeah.
I mean, the difficulty is you're citing a case as a reinsurance case,
Yes.
where different principles may apply. But under the Third Party Rights Against Insurer Act, Section 1, subsection 4, if there's a judgment that, which says that the insured is liable to the third party, then that liability is established. And as I read the Act, one thing the insurer can't do is to seek to go behind that judgment and say, well, you didn't run, in this example, you didn't run a limitation defence when you could have done. You, the insured, that is. Whereas in the sort of scenario that's being considered in AstraZeneca, the position may or may not be the same. As my lady says, very often reinsurance policies will contain provisions about, for example, consultation with the reinsurers or whatever before a settlement is made or something like that. So I think one could be a little careful reading too much into AstraZeneca for present purposes. Anyway, there we are.
As far as Section 2, subsection 4 is concerned, and coming back to my lady's point, the one thing that does appear to be clear is that the draftsman of the Act, the Law Commission, all the people who gave evidence, none of them had Larnell in mind. It doesn't feature anywhere. I'll come on to that in due course. But when one is reading this, with respect, not very well drafted section, one has to bear in mind that there's no indication that anyone had Larnell in mind.
There's no indication that anybody in the Law Commission thought that somebody would say that the insurer was able to take a defence which wasn't open to the insured.
Well, it's open. The wording is the company rather than the liquidator. Of course, I accept the Company Acts by the liquidator, but it is the company. And we say that if it's been done in ordinary proceedings, the company would have been able to take that defence, relying on what Justice David Richards said. The
committee which considers the bill was in fact chaired by Lord Lloyd.
Yes, it's an extremely distinguished one, and Lord Mance gave evidence, but nobody looked at Larnell. It never got mentioned.
Lots of cases didn't get mentioned.
I'll come on to that. Can I move on to Section 6, please? Which is the definition of relevant persons in the case of companies, corporate bodies. Now, for this purpose, I'd like to start, if I may, with the original Act, because Section 6 was differently worded. And the original Act is at tab 12, starting at page 35. And
Right, tab 12.
tab 12, and it's page 41.
It's tab 11 in line, but
It's definitely page 41.
Definitely page 41. It's, I think, something.
So we're looking at the Third Party Rights Against Insurers Act 1930.
No, it's the 2000. It's definitely page 41, which is
That
the
is
2010
Rights
Act.
Against Insurers Act.
Well, I tell you, this bundle is what we appear to have in tab 11, at least I have, is the Third Party Rights Against Insurers Act 1930, about which one can purr quietly that it takes up nearly 3 pages.
Could your logic go to the next tab?
And then we get, then after that, we've got pages and pages of the 2010
Yes.
Act.
So it's page 41.
Well, it isn't actually. I mean, the original version of the 2010 Act, if you're looking for it, is behind tab 12. It starts at page 56. And which section were you after?
My lady, page 56 is explanatory notes.
Oh, sorry.
It's page 41.
35.
Well, anyway, page what?
41.
That's right, page 41. Okay, let's have a look at that.
And the heading is corporate bodies.
Yes.
And subsection 1b, a corporate body or unincorporated body is a relevant person if the body has been dissolved under sections 1000, 1001 or 1003 of the Act, and the body has not been restored to the register or ordered to be restored by virtue of section 1031. Now, I mention this because my learned friend suggested that section 6A was an afterthought and perhaps hadn't been properly thought through, but wanted to make the point that it was always one of the purposes of the Act to deal with dissolved companies and to reverse the decision of the House of Lords, which said that dissolved companies were outside the 1930 Act. So it's always been intended that dissolved companies would be included, and that includes companies that were dissolved following liquidation. That's section 1001 of the Act. That's all I wanted to show you in the old Act. We can then go back to the up-to-date version, please. So subsection 2 has a list of 6 categories of body corporates or unincorporated bodies which are relevant persons. A lot of these are new in 2010. So the first one is a voluntary arrangement, and plainly General Rolling Stock has no application there. The next one is the body is in administration, and I'll just go through the categories and then I'll come back to administration, because there's some more things that need to be said about that. Then there's a receiver or manager has been appointed under C, but that needs to be read together with subsection 9A on the next page, which says a person appointed in accordance with Part 3 of the Insolvency Act includes a reference to a person appointed under section 101 of the Law of Property Act. So that brings in LPA receivers as well. Yeah. Then there's a D is a voluntary winding up, which would include both members and creditors voluntary winding up. Then there's a provisional liquidator, and then F is body is being wound up by the court following a making of a winding up order. Now, as far as administration is concerned, the position originally was that an administrator had no power to distribute, and the authority I mentioned yesterday and said I would bring today is Re Maxwell Fleet, decision of Mr. Jules Show, which is in the supplementary bundle at 1583. And the learned judge at 1588, the lower half of the page, explains that it's the power to distribute, which is what he calls the immensely strong reason for context for laying down a principle of law that limitation periods stop running. This is 1588 at letter F. And he says that administration has none of this. It's not involved with the collection and realisation of all the assets and the distribution to the creditors. And that leads him to the conclusion that General Rolling Stock does not apply to administrations. Now, as my Lord Justice Lewison noted yesterday, the rules have been extended. The provisions of Schedule B1 have been extended more recently, and by way of a quick summary, we've referred to Palmer at page 1649 of the bundle. Sorry, 1649, and the highlighted passage. The Insolvency Act initially provided the administrator may make a distribution to a creditor but following the introduction of the moratorium in 2020 and the priority afforded to certain debts, paragraph 64A of Schedule B1 allows the administrator to make a distribution to a creditor only if the assets are sufficient to meet any debts or liabilities, and then refers to the next two sub-paragraphs, one of them referring to prefs and secured creditors, and then over the page, the discretionary power of an administrator to make payments which are calculated to facilitate the achievement of the overall purpose is further widened by paragraph 66 as amended. This authorises the administrator to make a payment otherwise than in accordance with Schedule B1 paragraph 65 and Schedule B1 paragraph 13 if it's likely to assist in that objective. And then for our purposes, it's at the bottom of the page, the last sentence, to be provable in administration, a debt or liability must be one to which a company is subject on the date in which it goes into administration or becomes subject to it after that date by reason of obligations incurred before that date. So what that appears to suggest, as far as I'm aware, there's no authority on this. What it appears to suggest is that where the circumstances arise which allow a distribution by an administrator to unsecured creditors, then general rolling stock will apply. But in situations where that doesn't arise, which is a number of administrations, then Mr. Sherq's ruling remains valid.
Yes, I mean, Lord Justice David Richards touched on this, though rather obliquely, in the mortgage debenture and Chapman case.
Yes.
Paragraph 13, he said, having referred to the moratorium,
Yes.
it's not a sufficient description of the purpose of the moratorium in paragraph 43.6. An administration may be a prelude to limitation, or once an administrator gives notice of an intention to make distributions to creditors, may become a substitute for liquidation.
Yes. Yes.
So that's why I was puzzling about
Yes. Yes.
once the administrator is in charge of a distributing administration,
Yes.
general rolling stock would apply.
Yes. So the conclusion from that would appear to be that in the first instance, unless and until the administrator is put in charge of distributions, general rolling stock does not apply. And it may well be the case that the whole administration will conclude without that ever arising, or it might not. So that's section 6A, sorry, section 6, and the conclusion to be drawn from that is that there appear to be some situations in which a company can become a relevant person, which are situations in which general rolling stock may be applicable to the company, and there are other situations in which it's plainly not applicable. And if I was looking for any policy sense in why some are included and some are excluded, and why the treatment should be different for the purposes of the 2010 Act, it's very hard to see any rationale for that.
Well, I don't see actually with respect how that has any bearing on the issue that's before us, because the question really is whether or not there is parity between the position of the insured and the insurer for the purposes of defending the proceedings, or raising an issue of a by way of defence.
Yes.
And it may well be that there are situations in which it would be open to the administrator or whoever to take a limitation point, just as the insolvent entity would be able to take a limitation point. But there's no disparity in that situation. We're concerned with a situation in which it is said that there is, I know you contest it, but it's said that there is disparity because the liquidator would not be able to take the point and the insurer says that he can.
Well, lady, clearly the task for the court is to construe the Act, but insofar as one's looking at context and purpose, as far as one can establish it, there doesn't appear to be any logic in the distinction. So far as the victim is concerned, the victim, certainly the sort of victim that we're dealing with here, an unsophisticated person, wouldn't be aware of whether the insured was in administration or liquidation, or what the difference between the two was. And yet, on Mullen and Friends case, it would have a very real make a real difference to the outcome. and that there's no logic in that.
Well, the logic is that there's a decision of the Court of Appeal that says that general rolling stock applies in the case of liquidation. The fact that there are other ways in which somebody can become a relevant person which don't, in which the general rolling stock principle doesn't apply, doesn't seem to me to answer the point, which I think is really the point my lady's putting to you. I mean, one can say again,
Yes,
it's another example of a way in which nobody's thought these points through properly
yes.
in this piece of legislation, but that's neither here nor there, because it seems to me, unless you can say that Larnell doesn't apply for some reason,
Well, I'll be going on to explain why, because
it stands in your way.
yeah, I'll be going on to explain why the Act is differently structured in such a way that it doesn't apply. And my first submission as to Larnell being wrong, I appreciate this court can't overrule it, but what I would submit, putting it in crude terms, is that that's a good reason why, if the court is able to conclude that the Act is differently worded, it should be pleased not to have to apply Larnell. That's really what it comes down to. Turning to section 6A,
Yeah.
the wording is new, and it widens the categories of dissolved companies beyond, although the principle remains the same, dissolved companies being included, it widens it. And it's very briefly worded. A body corporate is a relevant person if the body has been dissolved, and then subject to two exceptions only. And one is if something has happened which had the effect the body is treated as not having been dissolved, so that would be where it's been restored to the register. And the other is partnerships only if their body's corporate. What this means is if a company is dissolved, and the company would be dissolved either following or winding up, the conclusion of the liquidation, or administratively because it struck off for failing to file annual returns, or those would be the two most likely reasons for dissolution. And if it's dissolved following or winding up, then on the appellant's case, general rolling stock never ceases to operate, and there's no limitation period. And that does seem extraordinary.
Might be said that it would be even more extraordinary if the limitation period suddenly revived on dissolution.
Well, that too, but we say it never stopped running.
Well, I think the effect of the restoration is that the limitation period does revive, which is why the court has a power to make a limitation direction.
Yes, I've forgotten that.
It does revive. But in order to get the limitation direction, you need to satisfy the court that you would have called proceedings during the period in which the company remains dissolved.
I'm sorry, the limitation direction is usually for other proceedings against
Oh, I see.
third parties.
Yes, it is. So exactly. So if in the situation we are considering,
Yes,
the victim, as you've been
yes,
calling it, chooses not to restore the company,
yes,
then query what limitation period applies. If, on the other hand, the victim chooses to restore
yes,
the company,
yes.
then the limitation period will revive, subject to the court's power to make a limitation direction.
The
limitation direction would be in favour of the company itself.
exactly. It would be made to enable, let's say, a recovery action or something of that sort.
Well, it could be in favour of the victim.
It's not clear how that interacts with Larnell, because one would have thought, applying Larnell, that once the company is restored to the register, it's restored as a company in liquidation. and therefore any assets would continue to be divided pari passu, which means Larnell would continue to apply.
Right, and it's not an administrative dissolution, you're
Yes, yes. So in the present case, for example, if I can take you to the supplementary bundle, tab 3, page 30. Page 30, tab 3. This is on the application of the official receiver and liquidator. Secretary of State hereby directs that the dissolution of the company, and that's Heatwave, be deferred and take effect on the 13th of February 2025 unless a further direction is issued. So it's been postponed until 2025. And that means that if it gives rise to a fresh limitation period, the fresh limitation period won't expire for 6 years, which is 2031. And these were losses suffered in 2013 and 2014. But the limitation period.
Time's already started to run. You wouldn't have a fresh limitation period under general rolling stock. It's simply suspensory.
That would be one of the submissions made by my learned friend, is that there might be a fresh limitation period. And that would lead to...
I'm sure that would be right.
Well,
there we go.
We submit not.
No.
While I have that bundle open, may I just refer you to one other document?
Yeah.
Tab 22, page 95, which is the political letter of claim in relation to the Allen case. What I wanted to note was the letter is dated 6th of July 2020, and you'll see at paragraph 36, page 98, we're instructed our client noticed the damp and mould in or around October 2015, but it wasn't until the 1st of October 2017 that they believed cavity wall insulation could be a possible cause of the problems. Therefore, it was only then that our clients had the requisite knowledge under section 14A. Now, HDI doesn't accept that, but that is the case that was being put by SSB law on behalf of Mr. Allen. And they're saying time ran under section 14A from the 1st of October 2017, but they didn't get round to issuing their claim form until the 14th of October 2020. So it was more than 3 years later. It was entirely, in other words, SSB law's fault that they missed their own suggested limitation date. And that's one of a very large number of errors made by SSB law in these proceedings. The court, of course, will decide the appeal on the law and not on the perceived fairness or unfairness of the outcome for these three individuals. But it's relevant to bear in mind that the outcome might well have been different if it had been competently handled by SSB law. And this may be...
Well, that's not really
the issue in this case.
We have to decide, is it?
No, it isn't. But there is one point.
It's a fact that there
is.
have been problems with SSB law, which are well known.
Yes. Yeah. But my Lord, I have been asked
fact that there are a whole load of other cases piled on behind the result in this one.
Yes.
But we have to decide.
Of course.
The issues of principle that are raised by this case.
But I have been asked to add one point, and that is the insurers want me to make it clear that if they were to be successful on appeal, they would not seek to enforce any liability for costs against the individual appellants in a manner that would involve payment from them personally, because they regard SSB law as the party responsible for the costs and would seek to make other arrangements, for example, by an assignment of the appellant's rights.
Yeah.
against SSB law or their PI insurance. So that's all I wanted to say on that point. I've referred to paragraph 6A. The paragraph 6A, sorry, section 6A of the Act makes it clear that the company doesn't need to be restored, and that gives rise to a real problem about how that interacts with section 2 subsection 4 and the limitation defence that might be run if the company had been restored but doesn't need to be restored. So section 2.4 enables the insured to rely on any defence that would be open, sorry, to the insurer to rely on any defence that would be open to the insured in proceedings brought against the insured. But it's obvious that the insurer can't rely on the fact that the insured's been dissolved. That would defeat the whole purpose of the Act. After all, the Act...
Well, there couldn't be any proceedings brought against the insured if it was dissolved because there was
No.
no entity against which to bring them.
Well,
so
that's-
you have
that's-
to postulate that it's been restored.
Yes.
Another example of bad draftsmanship, but there we go. But you must, for the purposes of subsection 4, you must surely postulate, if there are going to be proceedings at all brought against the insured, hypothetically, that there is an insured against whom to bring the proceedings. And a dissolved company is nothing.
That's certainly the case, but the question is what? Clearly, something has to be postulated, but the question is what. And
If you can come up with an alternative, please do.
yeah,
It
well,
seems to me that that's the obvious one.
yeah. The appellant's argument involves assuming a hypothetical restoration, which doesn't need to happen and probably won't happen, and then uses this to seek to imply into the Act that it must take place within the permitted period for restoring a company, which is 6 years, and that's
You can have any proceedings against the insured.
yeah, and that's how they get to their argument that the limitation period is 6 years from the date of dissolution, which we say would take you up to 2031 in this case. So
The alternative is that the dissolution simply starts the limitation period running again, it already having started since the date of the accident or whatever it is that's given rise to the claim.
we say it doesn't arise, of course, if general rolling stock doesn't apply under the 2010 Act. So
Well,
it's
it doesn't arise if you're right about general rolling stock, but if you're wrong about general rolling stock, then it obviously is an issue, isn't there? as to what-
absolutely.
Dissolution.
Can I ask you a question about 6A1?
Of course.
How do you dissolve an unincorporated body?
I'm sorry, how do you...
Dissolve an unincorporated body.
Well, I wondered about that as well.
Is this a club whose members fall below 2 or something like that? What is it?
Well, I know that there is provision now for insolvency procedures in relation to partnerships, but I'm not sure whether they result in dissolution. But it is odd because normally you'd only need to dissolve it if it's a separate legal entity, rather than a shorthand way of saying a relationship between the members.
I mean, that's what the law says.
Yes.
Unincorporated body is a relevant person if the body has been dissolved. And
Yes.
I don't understand what that means.
Well, whole subsection is. If the effect of dissolution is cessor of existence for present purposes, it's difficult to see how you can be any sort of person, relevant or not.
Yes.
It must be some sort of deeming provision. So anyway,
Yes. Yes.
We're not in that territory for present purposes.
No. Can I move on to section? Oh, sorry. I should say there is, of course. I accept that there's a potentially unlimited period in relation to personal injury claims, where the power to restore a company is not limited for 6 years, but that's expressly dealt with, of course, by the Limitation Act, Section 33, and by the Companies Act, and there is a discretion. And that's how Parliament has chosen to deal with it, so to prevent open-ended liability. Section 12, if I may move on to that, is headed Limitation and Prescription, and we would say this is where you would expect to find any carve-out in respect of limitation. And section 12.4 is something that my Lord Justice, the Chancellor raised with my learned friend, and with respect, I agree with what my learned friend said. This is dealing with one very specific situation, which is where you've already started proceedings against the insured. Then the insured becomes a relevant person. Then you need to get a declaration against the insurer. By that time, limitation has expired, and there are problems with Section 35 of the Limitation Act and CPR 19 in whether you can join a party to proceedings outside the limitation period. And rather than amend the CPR, it was easier just to put in a specific provision. So that's what 12.4 is aimed at. But we say
Well,
what
it's
that,
not just the joinder point, though, is it? If you look at the language, it's not just a point about eliminating the problems of joinder. What it's basically saying is that the insurer
yes,
can't take advantage of the fact that the Limitation Act, as I read it, that
Yes.
the limitation period has expired. So you've started proceedings within the Limitation
yes,
Act.
yes,
But the fact that the insurer is not being sued as a
Yes.
result of this particular process under
yes,
the 2010 Act
yes,
doesn't mean that he can then turn around and say, oh, well, the cause of action arose more than 8 years ago and therefore it's time bar. That's what this is about.
my lady, I would submit it is. Your ladyship's point is dealt with by the joinder point, because if you were allowed to join the insurer outside the limitation period, the joinder, of course, relates back to the original date of the claim form, and therefore you've automatically cured the problem. And that's why it's only this limited point of joinder, which actually includes all the limitation issues.
I mean, what it's dealing with surely is a broader question, isn't it? Which is just, so far as a claim against the insurer is concerned, limitation, if you go down the old route, which
Yes.
is what this is talking about,
Yes,
limitation against the insurer doesn't start running until the date of establishment of the liability of the insured to the third party.
yes,
That's all it's saying, isn't it?
yes,
And now that may have implications of all various kinds, but I mean, that's the basic
yes,
point.
yes.
I mean, I'm not sure, in a sense, why it's necessary to have it, because there wasn't an equivalent provision, I don't think, in the 1930 Act.
No.
But
Well, it didn't
you
need to
certainly
be.
couldn't have, because you needed to establish the liability of the insured to the third party. Limitation wouldn't arise until you had done that anyway.
I see this as a belt and braces, actually.
Yes.
It's there for the purposes of clarifying, so that some bright spark doesn't say that the 2010 Act has changed matters and that the limitation period now relates back. It may well be connected with Mr. Halpin's joined
Yeah.
point.
But my lady, it only arises in a very narrow situation, which is where you've already got proceedings by the victim against the insured,
Yeah.
which was started in time.
But if you're standing back and looking at the bigger picture, I mean, this all fits the Parliament's intention that there should be parity of position as between the wrongdoer
Yes,
and their insurer in
Yes.
terms of defending the action, doesn't it?
Yeah.
Because it means that the insurer is not being able to raise a point that wouldn't be open to the assured. So if you're just sort of looking at it from, as I said, the bigger picture, the wider perspective, it all fits. It's all part of a coherent policy whole.
One can read it that way, but it's actually worded rather more narrowly than that. And the point we make, which is perhaps your ladyship's point, but turn the other way around, is that this is the only carve-out for limitation, and it's a very narrow one in this particular situation.
Well, I thought the point you were making was that it is a narrow carve-out, and therefore there isn't any other carve-out for limitation, and one should assume that because there's only this specific carve-out, that there is no other carve-out.
Yes, yes, precisely.
Well, then that isn't the other side of the coin of the point that I'm making. I don't think. As I'm saying, you've got to look at the overall policy of the statute. The policy of the statute is that you should treat the insured and the insurer, basically the insurer and the insured, as effectively standing together and falling together as one.
That policy, when we come to look at the Law Commission and explanatory notes and so on, there are certainly suggestions of that policy, but it was all done without any reference to any realisation of the impact of Larnell.
Well, it's not got anything to do with Larnell, this one. I mean, as you accept, it's very narrow because it's dealing with a scenario, isn't it, where first of all, it seems to me it's only dealing with situations where at the very least, the third party has commenced proceedings against the insured direct.
Yes.
In other words, is going down the old route.
Yes.
And then at some stage, these subsection 1 and 2, at some stage brings a claim against the insurer for a declaration.
Yes.
But in circumstances in which the proceedings against the insured have yet to reach a conclusion. And it deals with limitation issues to do with that.
Yes, yes,
Precisely. I can see how that might, in a complex case, that might arise.
Yes, yes.
And also it fits in with the general policy, which is that the 2010 Act was certainly not intending to deprive anybody of the rights that they had under the previous
My
Act.
lady, that's a point I'd like to come back to, if I may, because I don't accept that with respect.
Section 12.1 applies where in-time proceedings have started but haven't concluded against the insured. Section 12.4 deals with proceedings which have established the insured's liability to the victim.
Yes.
So if there were proceedings, they have concluded. There's been an arbitration award or whatever.
Yes.
Section 12.1 deals with ongoing proceedings.
Yes.
And then section 12.2 says that the insurer can't rely on the expiry of the limitation period.
Yes.
Unless the insured was able to rely on it in the action which has already been started.
That's right, and that's the point about joinder.
Yeah. But one might think that that preclusion of the insurer's reliance on limitation implicitly is saying that the insurer can rely on limitation in other circumstances.
Precisely.
That is to say, where no in-time proceedings have been brought against the supplier, the insured.
Yes. Yes, precisely. That's precisely the point. Can I go on to section 14? Which we say is a very important section.
I don't accept it, but I can see it.
Section 14. Where? So I should say that one of the defects that was addressed by the 2010 Act was that the 1930 Act didn't expressly say whether the victim retained his right to pursue the insured for the same loss as he was entitled to claim from the insurer by virtue of the assignment. One might have a view as to whether it was likely he was entitled to or not, but the Act itself didn't say so. And that was one of the issues that needed to be addressed by the 2010 Act. So what Section 14.1 says, where rights in respect of the insurer's liability to a third party are transferred under Section 1, the third party may enforce that liability against the insured only to the extent, if any, that it exceeds the amount recoverable from the insurer by virtue of the transfer. So this is a new provision, and it makes it clear that the victim can't prove in the liquidation in respect of such part of the claim as is covered by insurance. So
This is about enforcement.
it is.
Yeah.
And we say that absolutely it's about enforcement, and hence we say that that part of the claim arises outside the collective enforcement procedure. It never falls into it.
Well, the trouble is, you don't know how much the amount recoverable from the insurer is until such time as you've concluded the proceedings brought against the insurer,
That's
the declaration. So until such time, a prudent person is going to prove in the liquidation for the lot.
Yes. Yes.
And there's nothing there, it seems to me, that stops them.
Nothing that stops them because it's all to do with enforcement.
Yeah.
Yes. But our submission is that the combined effect, Section 1, sorry, I should go on to look at the rest of Section 14. It's subsection 6. For the purpose of this section, the amount recoverable from the insurer does not include any amount the third party is unable to recover as a result of a shortage of assets on the insurer's part or a limit set by contract of insurance or the fund available. So there might be defences available to the insurer, there might be insolvency of the insurer, there might be excesses or other reasons.
Well, if you had a liability policy that covers for a total amount of claims in the aggregate, you've got a large number of claims and they've already eaten up
Paid.
Yes, absolutely.
two-thirds of what's left. That's simply making it clear that that's not, doesn't fall within an amount recoverable from the insurer, which takes you out of the ability
Yes,
or deprives you of the ability to enforce the liability against the insured.
yes,
That's all it's doing.
yes,
Not
yes,
sure how necessary it is really, but I follow the point.
yes. And then subsection 7 is worth noting that it expressly refers to the Financial Services Compensation Scheme. So the draftsman was aware of the existence of that scheme and made special provision for it in that situation. And that's the point that I'll come back to when referring to my learned friend Mr. Lynch's submissions, because he said that the Act would have a particularly devastating effect on the FSCS, and we say that if the FSCS needs special treatment, it should have been provided for in the Act. But before I comment on Section 14, can I just also take in Section 8, which goes with it, and that says, where the liability of the insured to the third party is less than the liability of the insurer to the insured, ignoring Section 1, no rights are transferred in respect of the difference. So it's obviously the smaller of the two. If for any reason the insurer pays out more to the insured than the insured will be liable to pay to the victim, then it's the smaller of the two. So this makes it clear, if you read that together with Section 1 and Section 14, that we have a bespoke statutory assignment of a limited tranche of the insured's right to claim indemnity from the insurer. And to that extent, to the extent that there is an assignment, the victim is not able to claim against the insolvent estate. I take on board my lady's point that one may not know at the outset whether or not the policy will respond, but once it's become clear that it does, then it is clear that it falls outside the collective enforcement procedure and it's outside the insolvent estate. We actually have a transfer of the rights.
So you say this is not a mixed claim anymore, it's a bifurcated claim.
Exactly, and that's why it's different from the 1930 Act, and that's why even if even though the court is bound by Larnell, it doesn't have to be applied to the 2010 Act.
Well, just help me as to the situation in which Section 8 arises. I mean, this is dealing with a situation where the insurer is under a liability of the insured, which is
Yes.
greater than the liability of the insured to the third party, which is
It's not easy to imagine.
doesn't seem a very likely scenario.
Well, it's the cost.
Well, if your claim falls within the excess, for instance, there's no liability on the part of the insurer because the claim's within the excess, but the insured does have a liability to the third party.
This is the other way around.
It's the other way around.
It's the other way
That's
around.
the difficulty with it. It's the other way around.
Yes, I mean, it's hard to see why, under a policy of indemnity, the insurer should be paying more than indemnity.
Can't be dealing with going back to the motor example.
Yes.
You can't be dealing with a situation where what's being talked about is a liability of the insurer for something completely different that isn't even the liability section of the policy. That makes no sense at all.
It's very difficult to actually think of an example because I was thinking of contributory negligence, but even there, the damages would simply be reduced and that would be the subject of the indemnity. You wouldn't find the insurer paying out more.
Yes.
No, quite.
I'm actually struggling to think of an example where the insurer
Yes.
would pay out
And
more
the one thing
because the indemnity.
that's long experience of doing insurance cases both at the bar and on the bench has taught me is that no disrespect to your clients, but the situation where an insurer voluntarily pays out in advance for a liability that has yet to be established,
Yes.
you can count on the fingers of one hand, I suspect.
Well, the explanatory notes give an example.
Oh,
They
do
say,
Oh, well done.
1568,
And they say,
an example is where the insurer is obliged by the policy not only to indemnify the insured in full, but also to reimburse the insured for costs incurred in mounting a defence to the third party's claim.
It's the costs point.
okay, it's a cost point.
And it's seeking advice on whether the third party's claim is likely to be
Right.
successful.
Okay.
That makes sense.
Yeah,
Yes.
if that, then it does make sense.
Yes.
Yes. Yes. So this brings me to the point that as to whether one gets a different result using the old route,
Yeah.
so-called old route. Let me say first, calling it the old route is misleading because the 1930 Act no longer applies. Any method used has to be under the 2010 Act.
Why is it a misnomer to call it the old route? It's under the old statute.
It's not under the old statute because the statute has been
Sorry, it's the route that was
the route that
available
was,
under
was
the old
yes,
formerly. So
precisely.
whether you call it the old route or the new route, it's not a route that can. It's a route that's been replicated.
It's a route that's been replicated, but with some differences, as we saw in section 14. As my Lord Justice Lewison put it, the claim is bifurcated and no longer mixed. That's the point. Now, in practice, the most likely outcome will be that the victim will seek both declarations against the insurer, and there will be no need to involve the insured unless there is both an uninsured sum and a real prospect of recovery of that sum in the insolvency. If the victim does decide to seek recovery from the insured, that will be for a different sum that he may not know whether it's how big the sum is or how much of it falls to the insurer and how much to the insured. He may not know that till he's brought proceedings, but conceptually it's always is a different sum. And it's a sum that's not recoverable from the insurer. And
It won't always be different because let's suppose the insurer's taking a non-disclosure defence.
well, it'll be different in the sense that once the proceedings have been determined against the insurer, it will be
that's
clear what the
different now.
insurer's liable. So I accept at the outset one may not be able to identify how big the sum is, but conceptually it's possible to identify it as being such sum as cannot be recovered from the insurer. And that's always going to be a different sum from the sum that is recoverable from the insurer. and where the limitation period, so if we take first the case where the limitation period against the insured has not expired, the victim would either join the insured into the same action or he'd seek to prove in the liquidation. If he,
Hang on. Say that again?
sorry, if the victim, sorry, if the limitation period of the victim against the insured had not expired,
Yes.
then the victim would have the option of either joining the insured in liquidation into the proceedings against the insurer or to prove in the liquidation. And if he joined the insured into the existing proceedings, he may well be required to give an undertaking not to enforce outside the collective enforcement mechanism. That's what was said by Lord Justice David Richards in Mortgage Debenture in Chapman, so that he doesn't get an advantage. So he will end up getting the same practical result whether he joins him in the proceeding against the insurer or whether he proves in the liquidation. If the claim against the insured is statute barred, we say that, certainly in the case of a creditor's voluntary liquidation, there's nothing to stop the insured, the victim, from bringing the claim in ordinary proceedings, unless the liquidator obtains an order to stop him.
Sorry,
And
you started off by saying if the claim against the insured is statute.
If it is statute barred, there's nothing to stop him bringing proceedings outside the liquidation. In other words, joining the company in liquidation into the claim against the insurer.
As a voluntary liquidation.
Yes. Whereupon the company in liquidation will plead a limitation defence, and we say that's how it should be. If the victim instead seeks to prove in the liquidation, he will be able to rely on general rolling stock as against the liquidator. But we say, because of the claim being bifurcated, that will not be binding on the because of the claim being bifurcated, that will not stop the insurer from running the limitation defence, and therefore one gets a consistent result. Would the court forgive me for a moment?
I don't understand.
Because you're starting at the beginning.
Well, I'm sorry for the unsatisfactory nature of this. I've just been told that the parties have settled.
I'm not surprised. There's a lot of activity going on behind you. I think it might be sensible if we rose for a couple of minutes.
I believe that the document's just being printed off to be
What are
signed.
you inviting us to do?
I invite you to rise for a few minutes
Is it inviting us to rise for a few minutes?
while the document is signed, and then it can be handed up.
You happy to rise?
Yeah.
We'll rise. Yeah, sorry.
My Lord, I'm very sorry to detain the court. Could I invite the court to rise for, if 10 minutes would not be excessive? It's just that the FSCS is quite likely to have something to say about what we do next, and I need a quick look at some authorities. Is 10 minutes too? I mean, I could wait. We could do it in stages.
I'm
And
very happy to say 10 minutes if you think we need 10. But we
I'm
say-
very grateful.
Well, on that clock, we say 10 past 12.
I'm grateful.
Court rise able.
also withdraw them. So that when you make that decision. I don't know, I haven't seen it. I haven't seen it.
Live stream still on. This, because we're aware of it, seems to be relevant. Is prudential here somewhere? Is prudential one of the ones where there's a draft, yeah, draft written judgment. That's our problem. What about the first? Can we get the hammer? Oh, great. Okay, and what because that seems to be the general. But the context is that there is
Have you got the draft order?
no.
Right, you need to see it. Do you want to come up?
Yeah, sure.
And then you can tell me if there's anything you don't like about it. We can work up. It hasn't yet been signed.
Okay.
You can tell me if there's anything you don't like, and we can see whether.
that doesn't, because sometimes the white's a bit misleading, not deliberately, that time that just I'm looking at. Can I have a look back at that again? Thank you very much. Okay, so, yeah.
Need to make sure that phone stays attached. How do I bring this down? Do I need to go any lower? Is that the whole? That's the final. That's the final position. Fine. Okay, so it all fits onto my page effectively. Yeah, yeah.
So we're keen to ask for a judgment. As I understand it, that will be opposed, but we think there's a discretion. Oh,
My Lady, I'm very grateful for the time that you've given us. What the appellants and the respondents have done is to agree a draft order subject to the court's approval. Copies are being printed as we speak, but they're not yet available, but it's a very short order. And may I read the draft to you? Upon the appeals, and it lists them, and upon the hearing of the appeals, upon the appellants and the respondent having agreed to the terms set out in a confidential agreement between those parties, dated 26 March 2024, copy of which is held by each of the parties, and to there being no order for costs. It is ordered and directed by consent that the HDI appeals are withdrawn by consent. There should be no order as to the costs of the appellants or respondents in the HDI appeals, and there shall be no order as to the interveners' costs of the HDI appeals. The appellants are hereby discharged from liability to pay the respondents' costs of the first appeal before His Honour Judge Khan, and then it gives the date of that judgment. So that's the draft order. That's agreed between my clients, Amanda and Mr. Bailey's. I understand that there are points that Mr. Lynch may want to make.
Yeah, okay. It seems very straightforward. Do you want to say anything, Mr. Bailey? Presumably you invite us to make that order.
Well, my lord, my clients have agreed it.
Yes, quite.
I may have something else to say in a moment then, my lord.
Well, if I may say so, as far as Mr. Bailey is concerned, it appears to be the forensic equivalent of coitus interruptus.
Right. Mr.
My lords and lady, it may come as no surprise to the court that the FSCS is keen, or does positively ask for a judgment. And if I could start, please, with core bundle tab 8. So it's core bundle 1, tab 8.
Yeah.
And this is the order of my Lord Justice Lewison, granting permission to appeal. And as the court is likely to recall, the reasons are, one, the grounds of appeal, and in particular whether FSCS and Larnell applies to the alternative route provided by the 2010 Act, raise a question of principle with potentially far-reaching consequences. It ought to be decided definitively by the Court of Appeal. I regard that as a compelling reason for the Court of Appeal to hear the appeal. So that's what I would respectfully suggest as the starting point. We then have the relevant...
Well, that may be right. The difficulty is that for better or worse, a settlement has occurred, as it were, midway between, or midway through Mr. Halpin's submission. So what are you suggesting? That we continue to hear Mr. Halpin, as it were, on the basis that even though his clients have settled, they still have to pay for him to attend? That's the difficulty.
It's one thing whether a case has been fully argued and then settlement takes place after the court's reserved judgment. That's a different situation.
Yeah.
Fully means sufficiently is the answer.
And you know, your status is that of an intervener. You're not a party to the appeal. No doubt your clients are very interested in having a judgment. That's presumably why they wanted you to represent them. But it doesn't follow from that this court should be prepared to, as it were, continue and give you the indulgence of a judgment when we haven't even heard it fully argued.
Yes, and I absolutely see that as really the central point. What I would propose to is briefly look at some authorities and then make some submissions.
If you can cite to us cases which raise the point my lord's just raised, which is where it's been fully argued, which sometimes happens, and then before judgment is handed down, there's a settlement. There are circumstances in which the court will hand down judgment anyway.
Yes.
We don't dispute that, but the difficulty is that's not this case.
What I respectfully submit is that the question as to what is meant by fully argued, and I respectfully submit that the answer to that is fully in the sense of sufficiently. The question is the court in the position to hand down judgment or not? And I'd respectfully submit the court is in that position because there were very full written skeletons, and in fact there were supplemental skeletons. So every point has been aired in writing. As my Lord Justice Flo, the Chancellor, commented earlier today, we haven't been taken by surprise by anything, and by that I refer generally to all of us in this room, the court and the parties. There have been no new points, and in fact that was the very reason given by the Chancellor for carrying on this morning rather than... yes, my learned friend Mr Halpin hasn't completed his submissions, but we know what they are. He's outlined them in writing with the one-page document handed out yesterday. He's traversed, I think, the majority of his points, if not all of them. Points in reply, there may be some, and there's a risk, of course, by asking for judgment in circumstances where it would be uncharacteristic and highly unlikely. I might have a good point to make in reply. There's a first time for everything. But imagining I did, there is a risk that I might say something worthwhile and I lose that opportunity. That is a risk that my clients are prepared to take. But does that answer the question as to whether or not the court is in a sufficiently advanced position to be able to give judgment? Absolutely. I'd respectfully suggest the court is. And that is what is meant by fully argued.
Well, but I'm more interested in, I'm not sure I accept that submission, but anyway, I follow it. I'm more interested in the context of where it has definitely been fully argued. Is there any authority you can point us to where an intervener has been able to insist that the court hand down a judgment when the parties don't want them to, don't want the court to?
I'm unaware of any authority of that kind. And in fact, I'm duty bound, I believe, to take the court, please, to the White Book.
Well, you're going to have a problem there because, as you may or may not know, we no longer have copies of the White Book in court.
My Lord,
It's part of the economy drive by the court service.
my Lord, my learned friend Mr Bailey has pointed out that his clients do not say they do not want a judgment. They are...
Well, that's he hasn't asked us to, and he's settled before the case is finished.
Even in a case which has been fully argued, the court has discretion either to give a judgment or not to give a judgment. Nobody's got the right to insist.
That's absolutely right. And in fact, the authority is going to take the court to... There seems to be, and we only learned about this point early this morning. I've only had the opportunity to look very quickly at authorities, but as I understand it, there does appear to be a difference between two situations. One is where there is a draft judgment and the parties settle, and the other one is where there is no draft judgment at all. And as far as I can glean from the White Book and the authorities I've looked at so far, it tends to be that the preponderance of the authorities where judgment is then handed down tend to be in the circumstances where there's a draft judgment, and I recognise that, but I'm duty bound, I think, to say at least my understanding.
Sometimes it's when the draft has been circulated that the parties then circulate.
Well, exactly. In fact, there are a number of authorities on that point. There is, however, a discretion of the court, because under, I'm sure the court will know this, under the practice direction to Part 52, where under paragraph 6.3 at 52A PD.15, where settlement has been reached, disposing of the application or appeal, the parties may make a joint request to the court for application or appeal to be dismissed by consent. If the request is granted, the application or appeal will be dismissed. So there is a discretion as on the appeal itself, and I read into that, I recognise it's an inference, but there is a residual discretion of the court to hand down judgment in any event. Certainly that seems to be, as I understand the authorities, that the one authority that we've got to hand up is the Prudential case, which again I'm duty bound to distinguish in at least two ways. One is that this was a case where there was a draft judgment. Two, this is a case applying the House of Lords rules. So there is a material distinction. I don't know if that copy has been handed up to the court or not.
No.
Oh, not.
Is it with the rest of those?
We have a copy here. May I approach the court, please?
Did we have it this morning?
No, I'm afraid we've only just produced it. Thank you very much. I'm grateful. I'm sorry for the late production, but we only became aware of this point. Sure. And thank you. And so it's on page 2008. And rather than take the court's time, if I could please invite the court to read from F for Foxtrot on page 2008 through to F for Foxtrot on page 2009.
So F, well, it follows that.
Yes, exactly. I'm grateful. Exactly, and obviously the key passage on which we rely is between A and C on page 2009.
Yeah.
I do not have a copy of this next authority with me, I'm afraid, but it's the authority, and the court may well know, it's the Prudential Assurance and Nylon Capital case. Oh, sorry. Oh, no, it's Barclays Bank and Nylon. Sorry, I apologise, I'm reading two lines at once. It's Barclays Bank and Nylon, and it's my Lord Neuberger, paras 74 to 75, identified a number. I'm reading from the white book, I'm afraid. I apologise, don't have copies of the authority.
Page.
And it's page 1261, so it's in the notes at 40.2.5. 40.2.5.
Sorry, 40?
.2.5.
Yeah.
Page 1261 at the top, the reference to Barclays Bank and Nylon Capital. And it's paragraphs 74 to 75, which obviously summarised here. And it's my Lord Neuberger identifying a number of factors that could point towards exercising the discretion to hand down a draft judgment, viz. The judgment dealt with a point concerning which there is a public interest in it being considered in a judgment because, for instance, it raises a point of law of potential general interest where an appellate court departs from the decision of the court below, where the case involves wrongdoing or an activity that ought to be brought to the public attention, or where the case is a matter of legitimate public interest. And this last factor was not held as being a powerful reason for handing down the draft judgment. So these are...
Well, both these cases are cases where there is a draft judgment. And Lord Justice, is it Brooke in Prudential, talks about there being a lis in being at the stage when the judge sends the judgment.
Yeah.
Yes, I accept that that is a distinction with this case. That is
Well,
right.
it's quite an important distinction, isn't it?
If we look at just the factors, just briefly, if I may, looking at the factors of the present case, obviously the FSCS and the market, for the reasons I explained in opening submissions, has a serious commercial interest in the outcome of this case. I've obviously addressed the court on whether or not the point's been fully argued. It's a matter of real importance. It's a matter of real injustice. If the appellant is right and the FSCS's intervention is right, then there is a matter of real injustice that needs to be resolved. A judgment one way or the other would be of huge help to to claimants, the FSCS and insurers alike. And then realistically, given the state of the law and the commentary in, for example, Collinver and Merkin, as we've seen, the chances are this point will come back to court. A lot of time and money has been spent, and most importantly, a lot of court time has been taken.
Well, parties have resolved their differences, but the order that was read out to us has not only would agree to the appeal being withdrawn, but agreed terms in relation to costs. I mean, your client may be in a different position, it's true, but you've chosen to intervene. And the fact that the matter may come back to court in another case seems to me to demonstrate a reason why we shouldn't accede to your application. We should leave it for another day. Anyway, there we are.
Just looking at the Lord Justice Brooks judgment on page 2009, of course he's referring to the House of Lords procedure, where Wolfer described that the appellate committee had not been prepared to give leave for the appeal to be withdrawn during the course of the hearing. I'm wondering whether there is a distinction between a situation where the parties wish to withdraw an appeal and where they wish it to be disposed of by some other means. As I understand it, once an appeal is in train, you need the leave of the court to withdraw it.
That may well.
So in the White Book somewhere, part 52.
Well, I think that may be the part I went to, where settlement's been reached, and the parties may make a joint request to the court for application the appeal to be dismissed by consent.
To be dismissed, yes.
To be dismissed by
I'm
consent,
talking
yes.
about the distinction between dismissing an appeal and withdrawing it. What the parties have agreed is that it be withdrawn. And just without the White Book in front of me, I can't tell you, but I thought that the rule was, if you want to withdraw an appeal after it's been lodged, you need the leave of the court.
That may well be. I'm afraid
The court has a discretion.
Yeah.
But,
Can't stop them compromising it on the basis that the appeal be dismissed.
I'm afraid I'm afraid I don't know. It's the short answer. I don't know if I have.
I think we've got your solutions. Is there anything else you want to?
If I could just have one moment, please, to take.
course.
I'm grateful.
Just one more point, Mr. Lynch. In the prudential case you've shown us, on page 210, there's a reference to HFC Bank. And just below, between D and E, Lord Justice Brooks says, early on Tuesday, the court was told the parties had come to terms overnight. Draft judgments were therefore not made available. The parties had therefore not been shown the judgments which were going to be delivered at the time they settled their dispute, and this, in my judgment, makes all the difference.
Yes, I accept that there does, certainly in the notes of the White Book, there does appear to be a distinction drawn as far as I can see. I'm afraid I simply haven't had time to review all the authorities, but that appears to be a distinction here.
The point being that if they've been shown the draft judgment and then settled, that's one thing. But where they haven't been shown the judgment seems to make all the difference, as you say, let alone in a case which, despite your submissions, the argument hasn't finished.
My Lord, I understand. If I could just have that one moment, please, just to quickly take instructions. Sorry,
Yeah.
yes. Sorry, I'm grateful. Just two very quick points. One is that in the Barclays case, as I understand it, there was no draft judgment. It hadn't been given to the parties. And so the factors of paragraphs 74 to 75, it is slightly different on the facts, but it's not radically different. And the only other point is if with more time I could try to find the rule about the consent point and withdrawal. I'm afraid I don't have that to hand.
Well, at the end of the day, I think it's accepted. There's a discretion in the court. So I'm not sure whether it's going to help us really.
No, I understand. I think there's nothing else I'd like to say, but thank you for the time. Grateful.
I think what we'll do is we'll rise.
Oh, my lord,
Do you want to say something?
my lord, if I may,
Yes.
I don't want to detain you for very long. I just wanted to reiterate the point that my clients have agreed to withdraw their appeals. They haven't agreed to any other formulation. And I also am instructed to say that my clients are neutral on the question as to whether or not the court should deliver a judgment. We certainly don't oppose you doing so. And in my duty to the court rather than to my clients, I would, if it assists at all, I would suggest that my own friend Mr. Lynch is right to say the court retains a discretion as to whether or not to give judgment.
Yeah.
And the Barclays case is a case where, unlike the earlier decision, there was a draft judgment that had been circulated between the members of the Constitution.
It hadn't gone to the parties.
Hadn't gone to the parties. It had been prepared by one member of the Constitution, and the other members hadn't had a chance to consider it at that stage, but nonetheless that was sufficient. If all the other considerations are taken into account, to justify the exercise of discretion on that, in that case. But it's a matter for you. The point I want to make, my lord, is this: it's a matter of discretion. It's a matter
Essentially, our job is to decide disputes, not to give advisory opinions on the law.
Let alone to intervene. It's no disrespect.
No, no.
I mean, that's the.
I understand. I was only trying to assist, my lord.
Well, unless anybody else wants to say anything, I think we'll just rise for a couple of minutes. Don't go away. We'll hang on.
Court rise if able.
Well, I've got to be careful because I've agreed to.
Court rise if able.
In the particular circumstances of this case, where parties have resolved their differences during the course of argument before the appeal had concluded, we don't think that it would be either appropriate or fair to the parties for the court to deliver a judgment, let alone listen further to the parties given that Mr. Halpin had finished his submissions. We'd have to do that in all fairness. It doesn't seem to us that that would be appropriate given the circumstances. So we propose to simply make the consent order which the parties have agreed between them. If you can just make sure that comes through the office in the normal way.
I'm very grateful.
So thank you very much. I won't say any more. And
What rice available?
Well done, David.
you were determined to try and scupper that.
I was.
Thanks so much.
That's really kind. Thank you.
You're very welcome.